this is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And
we had done that before the court ordered us to.
I know, but then I ordered you to, so did you do it again?
Okay, so.
Because I ordered you to.
Did you talk to Mr. Kendrick about the Donovan Thomas murder?
Okay, that answer would be yes.
Yes.
And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for another 40 minutes.
So there was some very, very, very interesting developments in court, and I'm going to cover many of them here. I'll say right at the outset, there was a particular part that featured a child throwing up gang signs. I'm not going to go over that again. You can find that in another video that I will link to in the description and that I will tag at the end of this video. But as you can see from the coming up portion right at the beginning of this video, we have a classic Brian Steele argument rant. We have the judge going off. We have Love getting brain freeze. Later in the video, it even looks like Love and Hilton are arguing with each other. We just have a little bit of everything. So without further ado, we're going to jump right into it. But one more thing, y'all, comment, like, subscribe. Come on, we're over here. We're watching hours and hours and hours of court, bringing you the best, most interesting, most important moments. So comment, like, subscribe, and let's get into it.
Judge, we're before this court representing Mr. Marquavius Huey on this matter. There's an intrinsic act that was listed in the state's notice to us back in November of last year concerning item 43, which is an intrinsic act that the state is alleging should be coming into this trial. Your Honor, that particular intrinsic act stems from a November 30th, 2021 alleged incident. It's a police chase, Your Honor. In that police chase, the state are presenting to the court that this intrinsic act is somehow connected to this case and should come into evidence. That's the issue before the court. The rule that I'm asking this court to apply in this particular case obviously deals with intrinsic acts and what are the requirements for them to come in. As the court is aware, and I've cited for the court Murphy versus the state, 354 Georgia App 560. It's a 2020 case, and the case stands for the proposition that in order for intrinsic evidence to come in, evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions as the charged offense. So the charged offense in our case, Your Honor, is stemming from an October 1, 2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. according to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car. When you look at the video, there's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not a nexus to any of the charges. And so the vehicle would not make it necessary to complete the story of the alleged crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted up. So no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. Mm-hmm. There's no indication that they were able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because of he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Dunaway on the indicted case and was taken into custody in court.
When was that?
That would have been in 2000. It was in December of 2021. Okay, so he shows up in the court, and he has been in custody ever since. So, as it relates to this Intrinsic Act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced by this coming in.
That was an effective assistance claim. That's
Sure.
a different kind of procedural stance than what you're talking about.
Agreed, but I agree. What I'm asking the court to look at is if this court says, hey, look, I think that it is intrinsic, I do think that it somehow meets one of those thresholds, then the court will go to the next step of whether or not there should be a 403 analysis to determine whether it comes in. So with that being said, in Hines versus the state that I previously cited, there was an intrinsic act, and the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant, there was a word that was used that she maltreated or injured or harmed her children, and the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running, and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct, and that would prejudice Mr. Huey immensely here, because these are things that are going to go to his character, it's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I determine that this is intrinsic, that video could be played without the audio?
I imagine they could potentially play it without the audio, but there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by a preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards in the circumstances of that. And I know that in the state's filing from November 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Good afternoon, Your Honor.
Hello.
The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle, so they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over. But
Was he driving? I mean, did they see
was
him get
driving.
into the driver's seat?
He was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. And so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was
Okay. Well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have. And these are text messages from November 8th of 2021. He says, just wait till after Christmas and the new year and turn yourself in, see what they talking about.
All right. Okay. So, and the chase is November 30th. So this is several weeks before then.
Correct. And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. And I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the new year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes in, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least was going to, had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case, because those text messages are from November 8th of 2021. So that's the evidence that I would have.
All right. Well, I mean, given that he says, yeah, they might lock me up, maybe they won't. I don't think that, I mean, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but that's my ruling, so.
Thank you.
All right.
Mr. Stillwell telling detectives who they say
All right,
killed.
that's 8. But okay. And you agree that that should be excised?
Partially, because what happens is that this is the part that we would ask, that we specifically would argue is not inculpating anyone. Okay. What Mr. Kendrick says is they say our crew. And he's, in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And then they specifically say, who within your crew? And at some point, Mr. Kendrick says, they say Shannon. That part we would agree comes out, but they didn't enumerate it exactly that way on this sheet of paper. So they say Shannon, we would agree comes out. He then says they also say Woody, and then they say Shannon and Woody. So the part where he's naming people that they say did it beyond our crew, or people that Mr. Kendrick identifies as his crew, or, you know, in acknowledging that there's a crew, we would argue that part, we would agree, concede that part definitely comes out.
Okay, so you're saying that they say our crew isn't Bruton, but when it goes further to say they say, whoever the they is, but they say Shannon, they say Woody, that part you agree?
Yes,
can be
I would say
redacted.
that specifically Shannon comes
Shannon.
out. Yes.
Okay. All right, and every other one we're going to need to look at.
And yes, I believe we should look at the rest of them.
And has anybody come up with any case law about kind of the interplay between Bruton and a RICO or gang kind of charge? Okay. Okay, that's fine, as long as you're getting me something. They're two separate, well, not entirely separate, but I think we can do this without knowing the answer to that.
Can I ask a question?
Uh-huh.
If I heard correctly, if the state is not, over objection, by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you're going to mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not ask the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear Mr. Kendrick say. So we don't intend to play the video
In total.
right.
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And generally speaking, the overall method of introducing the majority of his statements would be through questions to avoid any implication of Bruton.
All right. Well, if there are particular portions that you know you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that'll probably be helpful.
Okay.
I think that's easier, because if it's question and answer, it's easy to deal with.
Yeah, sure. So just let them know which of the portions. But okay, let's go through all of these if we need to, which it sounds like we need to.
Did you send it to me?
So do you want me to be, is there a transcript for this statement, or do I need to be listening to the audio?
There's we don't have a transcript of this statement.
Okay.
But we can, how they want to do this. Since the defense has timestamps on it that
Okay.
are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format because I have a specific time. And they
Sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says? Okay, that'd be great. Okay,
Yeah.
sure.
Can I just bring up another concern on this subject? The concerns aren't limited to Bruton. I still like. We're talking about playing a tape where Mr. Kendrick says that other people are saying. He's not saying anything that he knows. He's not telling on anyone, but he's saying other people are saying
Yeah.
that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
Yeah, no, I agree. That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So I bet Ms. Rilov's going to say we're not intending to elicit that.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Bruton is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talk to Mr. Kendrick about the Donovan Thomas murder?
Okay, that answer would be yes.
Yes. Did generally speaking, what?
Let me ask you this. Do you think that it's relevant for the jury to hear that, Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, the people on the street think X, Y, Z is relevant. The relevant part is his acknowledgement that
Our crew
was beefing with them.
Okay.
There was a us and a them that was in conflict.
Okay. So then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay.
Thank you for actually.
All right. So when we're going through any of these other ones, if there's something similar, just kind of let us know that. Okay. Okay. Well, let's just ask it this way. Do you have any intention of who's this coming in through?
There would be either Detective Thorpe, probably Detective Thorpe later on.
Is he even in this interview?
He's right there in front of you. To the left.
Oh, okay. I thought you had said Dennis and Gaither.
Dennis and Gaither are sitting in front of Mr. Kendrick. And Detective Thorpe is to his
also
right.
in there.
He
Okay.
is.
All right.
There are three.
So, I mean, you're not going to ask Detective Thorpe if Gaither asked if Williams was a reason why.
No.
Okay, so
absolutely
that
not.
would be one then. This example would be one where you could say, we don't intend to ask that anyway.
Okay, so we do not intend to elicit or ask whether defendant Williams was
All right, well, let's
whatever.
circumvent spending the 5 minutes listening to it if you know you're not going to use it anyway, okay? That would be super helpful. Okay, next.
But so when, again, this is one of those them, us, we, them situations. It is simply not one of those situations where we would be saying, you know, are they coming after y'all because of Thug? Are they coming after you because of we wouldn't be eliciting anything about another defendant. But if Mr. Kendrick is talking about a us and a them, like he is in this circumstance, they want to take my spot, things like that, then we would be putting that in. The reason I was saying we're looking at it in terms of Bruton is because if he's not talking about a defendant and he's not saying that person's name and inculpating him, then it's something that we will likely use. If there's a point at which I know that I'm just not going to even touch it, I'll do as the court has instructed, though. If, you know, and say, no, I wasn't even going to ask that anyway. It doesn't do us any good.
Okay, so then what I hear you saying is that while you're not going to elicit that somebody asked if Mr. Williams or Thug might be a reason people are after them, you would maybe ask about some part of Mr. Kendrick's answer there, which said something about whoever they is, wanting to take my spot.
Yes.
Okay.
And that we contend is not Bruton.
That would not be Bruton. Okay. Next, the PowerPoint.
No. It would
Okay,
come after the
PowerPoint. All right. Yeah, we can look at that. All right. Slide 1. I don't see how the state could possibly need that slide.
No, that's not. No, I mean, it's not. No.
Okay. Slide 1's out. Slide 2. This is just sort of.
These are identifiers that APD has. Identifiers that APD has identified, and
All right. Hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes.
Okay. So that one's out too.
If you say it is, it is.
Huh?
And
I mean,
just to make sure we're all on the same page, what you're referring to as slide number 2 is the picture that has an arm with a tattoo. Yeah. Okay.
Yeah.
Which also, coincidentally, is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All
looking at the title page. And then
Okay.
we're on the same page.
All right.
Literally.
Okay, good. All right. Slide number 3. What's y'all's argument for needing that?
Okay, we can.
Because we've still got some language on all of this too.
So we can take out. Well, we can take out all the language.
Mm-hmm.
We can take out all the language.
Okay.
Yep. Can you take that aside? John, may we be allowed to remove the Mondo board, the IT department?
Yes, that would be wonderful. We're not going to use it, so out it goes. So y'all go ahead and yeah.
Not right now.
Okay. What about these 5 pictures?
So the pictures, Judge, are just as he's talking, he would.
All right. So who are I see we've got
Defendant Williams,
Mr. Williams, Rich Homie Kwan.
Birmingham.
Are there pictures already in evidence of
Yes.
those 3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
Yes.
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is Defendant Williams. And as
there
pre the gang, pre the dispute, the war.
Okay. I mean, is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Hold on 1 second, Your Honor. We have videos of the groups of the
All right,
persons
so you
together.
could do a still from a video.
We
Okay.
can.
All right. How about slide 4?
This is just, Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that there's,
Is there a picture of Mr. Watts in evidence?
Yes,
but
there
they're
is.
demonstrative.
Look kind of similar to this?
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the
Are
indictment.
they going to, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes.
it's going to be crucial for the jury to see, here's Copeland and here's Watts?
Not crucial. But he will be talking about a specific interaction, specific.
Okay, well, he can
antagonistic.
talk about that without this. And if you need to, like, have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that
Do we have pictures already in evidence of that?
knew.
Okay, then this one's fine. Slide 6. With the stack of money and obscene gesture.
Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watt. So
Okay.
And we've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've had a video and
All
chase
right,
of
well,
him.
don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June. However, that was after 3 o'clock. And so we did not enter it again
Okay.
this time around. So I do not believe the video is in evidence. I'll double
Okay.
check, but I believe that was after
All
3
right.
o'clock.
Actually, good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts,
The flashing of the large sums of money.
not the flipping the bird.
I mean, I don't.
Yes, no?
The flipping the bird. I mean, it wouldn't have. Our argument is that it's relevant because it shows Mr. Copeland with that huge stack of money that we're talking about, and it makes
Is this the night of?
it's.
Or is this just?
You say the night of, not
the
John
night-
and Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a
Flipping the
bunch of
bird
money.
and holding money.
An exemplar.
It-
Good
it's-
word.
I think it's January the 8th. The 6th, January the 6th. So it was the night, it preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody J was punched out.
So this is a picture from the night that, it all got shot up or something?
I'll confirm, but that's
After-
what my understanding, that is January the 6th.
How do we know it's January 6th? Where does that date come
I don't
from
know.
from the photograph?
I don't know. Maybe they know what he was wearing to the club
The
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night, that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just,
here's what we mean about flashing money.
no, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So, the relevance bar is, of course, as the court knows, is a low
Yeah.
bar, and the fact that he's sitting there with that.
Okay. Well, he also is flashing the bird, though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe there's why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when we've got some more info.
Yes, Your Honor.
All right, slide 7. This just shows a couple of the, the Metro, but there's been testimony about the Metropolitan, right?
TIG studios that
Right.
Mr. Copeland is alleged to have shot up, or believed to have shot up.
We've had a number of crime scene photos ended of the Metropolitan, so there are a number of photos of that in already.
So it doesn't. There's nothing. If Detective Dennis is talking about this, putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that orients the jury, that is helpful to the jury, that is substantially similar to what that is exactly what he's talking about. So there's nothing that should preclude
Okay,
him from
and
showing it to the jury.
TIG is who's?
Think It's a Game,
Right,
is the company that Rich Homie Quan was under. That Think It's a Game Studios is inside
Right.
that building right there.
Okay. This one's fine. All right. Moving on to slide 8. So this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial Will Always Remember You part of that.
Okay.
And, the language about whether he's a high-ranking member of a rival gang, that's,
It can come out.
thank you.
But
I know it's asserted that he is, but this sets it forth like
yes.
fact, and that's for the jury to determine.
Yes, John. I'm just trying to X over everything.
Okay, so,
Did you have something?
those 3 pictures basically of Mr. Thomas and some of his
Brothers, family.
Well,
whomever.
I would object to the pictures of
Greed.
the pictures period. I mean, I don't know what the relevance is and what a jury would need, or how this would aid the jury in understanding any testimony from Detective Dennis to show pictures of him and various individuals just standing around.
So, do you want to elucidate us on that?
Yes, we can take.
Okay. So they won't use that one. All right, slide 9.
So slide 9 shows just the type of
Are these actual posts already in evidence?
no, we did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if you want to enter those as examples, we can talk
Okay.
about that. But
Okay.
otherwise, he can just testify that here's what happened on social media after the death.
Okay.
All right, slide 10.
Donna?
Yeah.
I would be objecting to Detective Dennis saying this is what I saw on social. Okay, you understand that.
Okay.
would be hearsay.
And how would, well, no, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted, and the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is part of is the evidence itself. Not that it's true. This death to the big homie sent the word out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
Were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes. There were public threats, social media posts, and the like. And these would be them.
I would be objecting.
Okay, well, that would. Okay. Yeah, and that would be overruled because it isn't being offered for its truth. Okay. But we can just do that at the point in trial. We don't have to have this slide.
Okay.
So it slides out.
Slides out. All right, slide 10. Tell me, I guess, what I'm looking at and why he's going to be using this.
So I think we can take this out. I think that this picture is already in any event.
All right. Slide 11. There's a lot going on this slide.
There he is. He can testify about that. It's basically it's Mr. It's the services of the victim in this case. So he can testify about it.
It's a good
Taking
question.
victim impact.
What would be the
Just-
relevance of how, many people were moved by his death?
Judge, if I may come back to the court on that, I can take out the slide and
Okay.
as to the questions about it.
All right.
So 11's out.
So the slide, yes, 11 is not going to be used, and she'll get back to me on the relevance of how crowded his funeral was.
He's very loved.
And maybe it is. I don't know. But all right, slide 12. So how about slide 12?
So we can take out that. It's a similar one as the one earlier, so we can take out. We can take that out in the same way and introduce it if we need to.
Okay. Thank you. Is the picture with the placards from obviously some shooting already in evidence?
I don't think this particular one is, but it will be. We anticipate that this will be admitted in
Well,
evidence.
if you want to present it to him and ask him about it, that's fine.
Okay.
Add the second one on there. Do y'all intend to have him talk about that picture?
We can take that out.
Okay.
So that, yeah, we can take that
All
out.
right. So then 13 essentially won't be used, and you can, if he can identify what's the crime scene photo, then he can testify to that. Okay. Number 14.
Do we? So, Judge, we don't have to, with number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay.
We would, yeah, as opposed to using it as a demonstrative.
Okay.
There's
And
some
I mean, if they're
photographs.
already in, then obviously if he needs to testify to them, he can. And if they're not in, he'd need to be able to, obviously you'd need to be able to lay the foundation.
Right.
but-
And we may just get, some of the ones that are, as the court has already pointed out, some of the ones that are already in and put them on just to use those as our exhibits with
Okay.
him.
Picture of him already.
I mean, presumably this shows everybody's in a relation to these three people.
It does. He testified about that. But this is just like putting faces to the names and sort of family diagramming, and I think we actually did that earlier. So it would be referring back to something that's already.
I'd be objecting. Your Honor, the mother, if I interrupt, I apologize. If the mother of Mr. Thomas testified to family relations, the father of Mr. Thomas testified to family relations, and Detective Dennis testified. Now, he may not have, actually. He may not have. So definitely the parents, the mother and the father, I would be, it's just repetitive.
Okay. Sounds like she doesn't intend to use this anyway upon further reflection.
15 is out.
All right. Slide 16. We still have a current intent to use this slide.
We cannot use 16.
Okay. Okay, 17.
17. We can as well not use. So what I think that what we'll do is just take some of the photographs that we've already admitted.
Okay.
And use those as the exhibits rather than trying to introduce whole hog.
Sounds reasonable. So 18.
Let's see.
Y'all still want to be using that?
No, we cannot.
Okay.
We cannot.
All right.
Well, except that I think that the photograph in the bottom right corner were guns that were recovered. But I'll confirm with Dennis. I won't need so that might be something that we could use as an exhibit and not a slide. So if there's anything in this picture, certainly not the top three.
Okay.
But if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it on a demonstrative slide.
Okay. And these are all
It was the stuff that was collected from one of the vehicles.
From an alleged rival gang?
Yes. after the shooting at 1006 Hill Street. Actually, not the rival gang. This was the one that was collected from the people who were shooting back at the people who were shooting at.
Okay. All right. Well, I mean,
But
I could anticipate some potential objections from the defense at the point in time if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this is from
well,
the
we'll
other
see.
side. This is
We'll
the
see
guns
what the
from
strategy is.
from the other side.
We'll see.
Okay.
Okay. That's what makes trials interesting.
So 18 is out.
18 is out. 19.
19, we have not yet introduced that photograph, but I think that we've,
The one on the bottom, or?
yes,
Okay.
the one on the bottom. Part of that photograph is part of what was talked about in the interview with Mr. Copeland that has been shown to the jury so far. So we could definitely take out the words, we'll do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
Okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe we should. I was going to say, rather than introducing the whole thing as just, here's his demonstrator that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're going to use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted
Okay.
or that we tender through
Okay.
him.
All right. And so that'll be true for the rest of this?
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, so she's just saying it's going to be easier not to. Because, I mean, I would imagine he's probably kind of like press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right. So then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine. Otherwise, I guess we'll just see what happens at trial.
Your Honor,
Yeah.
wouldn't the same rule that your court said the state now will give us what they believe they're going to introduce as an exhibit through Detective Dennis, and we could raise it with you?
Yeah, that would be helpful. I mean, you're going to want to take a look at this and then decide what you actually want to use. So once you kind of narrow that down, if you'll just let the defense know which ones you actually want to use, then they can raise any kind of objections that we could get taken care of outside of the presence of the jury beforehand. That's fine.
So
Thank you.
Can I just make an observation
Sure.
or an objection? So before this honorable court took over, there were lots of objections as to, it was Detective Dennis allowing to say his investigation. So not a witness came in, the crime lab person didn't come in, just he was allowed to say, I learned of, and these CAD reports, I objected to everything on confrontation clause and hearsay, and the former judge denied it, so it all came in. I think the state, is about to do the same thing with the same witness, and I will be objecting again, and I also have this section. I'm looking for Georgia cases.
Okay.
It says, I have a couple cases. This is United States versus Nguyen, Nguyen, F, that's wrong. 504 F 3rd, 561, 5th Circuit, 2007. Thus, while summary witnesses, which is what I call Detective Dennis, may be appropriate in complex cases in certain circumstances, they are improper for introducing evidence that the jury has not previously heard. We repeat our admonition that the government may not use summary witnesses for inappropriate means. While such witnesses may be appropriate for summarizing voluminous records, as contemplated by Rule 1006, rebuttal testimony by an advocate summarizing and organizing the case for the jury constitutes a very different phenomenon, not justified by the federal rules of evidence or our precedent. So, to me, this is what I call a summation or a closing argument, and I know that the court struck it, so I don't have the same exact situation as my motion to exclude this, but this whole thing is a closing argument. This is PowerPoint was a closing argument. I understand it's no longer like that. It's dismantled, and now we're going exhibit by exhibit and rulings. But my point to the court is if you can just, I'm not asking for an advisory opinion, but this is going to be, there's 2 Detective Belknap, 1 Detective Gaither, maybe 2, but 1 Detective Gaither I remember, 1 Detective Dennis. They've all been over objection, qualified as experts. They're on the exact same situation. And now we're going to replow. Detective Dennis already testified as to the alleged back and forth. He already said all this. Okay. So did Detective Gaither. It's all over objection. But I would object that it comes in now again.
All right. And what would be, what's he going to be talking about new? Why are y'all presenting him again?
So because he's sitting through some of these, specifically some of the interviews that we were talking about, some of the actual shootings that we're showing the evidence of, like on April the 28th, the Hill Street shooting. He touched on them. We did not get into, like, he as an expert talked about what their investigation led them to do and sort of what their investigation entailed. He didn't talk about the details. We won't be getting into rehashing something he's already talked about. The stuff that he's going to deal with now is going to deal with specifically the interviews that he conducted, depending on what the witnesses say. If there are some instances where, you know, we don't need to play the interview because they say exactly what they said, then we won't do that. But we're at a different part. He is a fact witness, and he's still he has still been qualified as an expert by the court. So we won't be rehashing stuff that he's done, and we won't be using, I'm not certain when Mr. Steele says, you know, he objects to summaries. As experts, they're allowed to talk about how they arrive at certain conclusions.
Yeah, I think there were maybe like a couple of different objections in there, but it sounds like one of the objections or potential objections would be if he's going to get up and basically rehash the same thing he already testified to about how, you know, the theory is that all of this came about because it was the culmination of, you know, some gang wars, basically.
We've already
that's already been covered, so he should not be testifying to that again.
Right. We don't need to, but specific, like the April 28th shooting, the Hill, like we haven't put up all the evidence in some.
Okay. Nobody in here is being charged with that shooting, right? That's part of the story of some of the crimes that are charged in the indictment, right?
I think the court is saying that they are overacts. Some of them are overacts that are listed in the indictment. If that's what the court is saying, the answer is yes. Okay.
So I'm maybe thinking of the Hill Street shooting as something other than what it really is.
The Hill Street is not. The Hill Street is not.
Right. That's when Woody and his girlfriend get shot at, right? Or no? Okay. All right. Sorry. There are a lot of shootings that I haven't been in this case the whole time. So, all right. So, but I guess, so let's take, for example, that one. I mean, we're not going to need to get into the nitty gritty of that one because that one, all that we need all for the jury to know for that is it happened. Some people believed it was a rival gang. It, made the beef worse. We don't need all the details about how many bullets were found, right?
That was Frida Reed. That was Lucci's mom. And so
that was another one. But
so the overt acts connect that shooting with the ballistics from that shooting.
Okay, so for that reason, that might be relevant.
And Lucci's a central sort of
right
opposition figure in the whole.
Well, I guess I'll just have to take them as they come. But we do not need a whole entire crime lab. Here is, what you would put in if you were the state prosecuting that shooting, when that is not an overt act and it is just something that happened along the way that's part of the story. I don't want us to be having a mini trial about that.
And we've scaled back everything in the indictment, even like we were saying yesterday with the Rodelius Ryan murder. We've scaled everything down like that. So it's not to.
So are there other objections encompassed within what you just said, Mr. Steele, that I need to be addressing?
I don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab a weapon that was used in this shooting and another shooting. To me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements in the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and bringing in the witness, or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was, over objection, Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall. By September 2014, there were no witnesses here.
Okay, well, that's the subject for cross-examination then.
It's hard to cross when I have no reports. I have no expert report. I don't know who to interview to say, no, that's not true. I never told them that. In fact, I told them something different. This is all, to me, like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to produce it to writing. This is all confrontation clause, and it's all coming in as a conduit through some, quote, expert. And it comes through with many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able to undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of y'all in court that there aren't expert reports. Does that continue? And y'all were going to circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been conducted?
For police reports, yes. We were actually, I think the court told us to do it for a specific act, and I can't recall which one it was, and we did, and there wasn't. But we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
Yes.
And that produced nothing?
No, we have nothing that we haven't turned over, because what the court required us to do was, it was for a specific one.
I don't think it was.
It
may have been for a specific one and then everything else. But anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So, no.
I'm sorry. Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes, we don't have anything extra. We will go back again because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD and in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I know, but then I ordered you to, so did you do it again?
Okay, so.
Because I ordered you to.
We have not inquired a second time, and I apologize to the court. We're going to do it again. I will do it.
I pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah. Well, Mr. Atkins, you could have done it.
Well,
Yes, Your Honor. I'll go make a phone call now.
Okay.
And can I mention something? It came out during trial, during a motions hearing, that there is what I'm going to call a black book. And it's all the gang information.
Yeah.
And okay, you seem like you know about it.
I've heard about this before.
Okay, well,
Yeah.
I don't know about it. And we were given the Heisman. We were told that we're not getting that. Detective Dennis said he no longer works at APD, so he has no access. Detective Gaither said the same. Detective Belknap, who continues work there, says that's not for public information.
Well, I would imagine it is not. However, if such a thing exists, do y'all know what Mr. Steele's referencing?
if he's talking about what Detective Dennis said that he used in the beginning of his career as a law enforcement officer where he collected information, I think maybe he called that maybe a black book. I don't know if he's talking about that or if he's talking about the information that they keep on gang members. I'll let him clarify, but.
All right. Do you know, Mr. Steele?
I'll take anything that has to do in any way with the testimony in this trial to either be able to go and interview the witnesses, confirm the witnesses. There was a lot of talk over objection. The policy of APD, how they qualify somebody as a gang member.
Oh.
It's self-admission. It's somebody else who's reliable, which say that they're in a gang.
Okay.
They hang out with somebody. All that's in this supposed book. I don't.
Okay, that's entirely different.
Okay.
Because-
So you now do know what he's talking about?
No, that's entirely different. Detective Dennis talked about, and Detective Belknap talked about how they identify gang members and what criteria they use.
All right. Is
not
that
true
something that is
is
in
something in a
writing?
black book.
Well, whatever. Is it something in writing?
I think that the criteria, those criteria that they use, that is something that is a written sort of criteria, and I'll get
All right,
that.
let me propose, if that's easy to get and they don't have kind of security concerns with it being provided to the defense, then provided, if they do have security concerns, then it can be satisfied by saying, Mr. Steele and anybody else on the defense team, you can come look at this written policy, at 12 p.m. on XYZ day over at APD. That satisfies it also. So in some way or another, if there is a written something that is how they classify, then give them access to it in one of those ways, okay?
I will, and we will also check to make sure that we've not already given them standard operating procedures as it relates to gang unit.
Well,
and gang
obviously, if they've got
identification.
it already, then they've got it.
But in terms of being able to cross-examine the witnesses on specific incidents that they've discussed, we've turned over entire files relating to each of these incidents.
Okay. All right. It sounds like what Mr. Steele's talking about is the sort of policy that you just mentioned that are the guidelines, the criteria.
actually want the specifics of who they spoke with. They're talking about.
All right. Well, they may or may not have anything like that in writing.
Well,
and you can always just interview the detectives
Well,
to ask them those things.
well, I have interviewed the
Okay.
detectives, and they tell me that they're not releasing that information. They would speak with somebody. They'd speak with Brian Steele. Brian Steele would say that Keith Adams is not involved in criminal street gang activity. That would go into some sort of book. Then they would speak with Carlton Matthews, and he would say that Brian Steele is in a criminal street gang. That would go in some sort of book. I'd like to see that because they're speaking about, we corroborated this. So I asked on cross, who did you speak with? I'm not going to tell you. Well, why don't I have the right to know?
I don't know. Maybe they consider them confidential informants.
He never said,
have to
I don't think he ever said, I'm not going to tell you, Judge. I think
All
that
right,
what
I'm not going to relitigate it. If it comes up again, we'll deal with it then. Okay. So I'm not even sure how we got on that. Oh, but Mr. Steele, you've said a couple of different times that you object to certain portions of CAD reports as being hearsay, and you were going to give me some law about that. And I don't know if other CAD reports are going to come in or not, but. Okay, well, provide it, and that way I'll provide it to the state as well, because if it's clear law, then they can just redact those portions of CAD reports which might need to come out as hearsay. All right, so we've done the PowerPoint. So I am going to give us another quick break, but I'm going to say, and I'm going to say this once, and I don't want to have to say it again. And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for another 40 minutes, just take the opportunity to use the restroom so that we don't then 30 minutes into court again have to take a break because now you can't hold it anymore. Okay? All right. So we'll have a little recess.